Chairman, you're live.
The meeting will come to order. Please call the roll.
This is a roll call for House Education, February 18th. Representative Braden.
Here.
Representative Erickson.
Here.
Representative Guggenmoss.
Here.
Representative Kelly. Excused.
Excused.
Representative Lawley.
Excused.
Representative Singh.
Here.
Representative Strzok.
Here.
Representative Williams.
Here.
Chairman Andrew.
Here.
Mr. Chairman, you have a quorum.
Thank you. Good afternoon and welcome to the House Education Committee. We have 3 bills on our table today for consideration. We intend to get to all of them. And for that reason, we will be limiting testimony to 10 minutes in opposition, 10 minutes in favor for each bill, with a 2-minute time limit on each individual speaker. House Bill 157 is now on the table for our consideration. Representative McCann.
Thank you, Mr. Speaker, committee. House Bill 157 is a parental rights bill. At least that's the title, but it could easily just be a anti-bullying bill. That's what triggered this. And the parents have just been run through the gutter as far as trying to get some remedy for this. There's varying degrees of bullying in the book, and I've sat down with 4 of these mothers for about 3.5, 4 hours. They're all very similar. There's probably a dozen or more. Some of them still afraid to come forward because of the retribution and the gaslighting by the various people, including school district people. The bullying that's going on is absolutely horrific. And the fact that these kids their form of bullying is actually dry humping. So they're just embarrassing the snot out of these kids. There's an argument that one of them might have even committed suicide over it. And that's absolutely uncalled for. And the fact that the school district has done anything and everything to try and slow roll everything is very, very frustrating. Now, I only have the parent side of the story because I did try to contact the school district via letter, and they filed an ethics complaint against me for that. So, and if you'd like a copy of that letter, I can make that available. Several of the parents have said they've gone to the police. I did not confirm that. The police said that it was a school district problem. So it's really left these guys out hanging to dry. And I mean, as a parent myself, if that was done to my kid, I'd have a hard time with that. So at any rate, to get back to what this bill is about. The Wyoming Government Claims Act, WGCA, is a law that determines when government entities can be sued and under what conditions. Government entities are generally immune from lawsuits unless the legislature is has specifically created an exception. HB 157 creates a new section, Wyoming Statute 1-39-125, and adds violations of parental rights to the list of statutory exceptions to government immunity. This means a government entity may be held liable if it violates parental rights under Wyoming Statute 14-2-206. Normally, a claimant must file a written notice of claim within 2 years and comply with strict statutory requirements before bringing suit. HB 157 removes that notice requirement for parental rights violations, so parents do not have to comply with the standard government claims notice procedure before filing suit. Under current law, the Government Claims Act generally prohibits awards of attorney fees. HB 157 overrides that limitation for parental rights violations and requires a court to award reasonable attorney fees and costs to a prevailing parent. This ensures parents have meaningful access to the courts when their rights are infringed. To go through the bill, HB 157 ensures that parental rights are already recognized in Wyoming statute are enforceable when they are infringed on by the government entity. I will briefly walk through the bill and explain what we're trying to do. Page 1, creation of liability, Wyoming statute 1-39-125. Page 1 creates a new section within the Wyoming Governmental Claims Act stating that a government entity is liable for damages resulting from a violation of Wyoming statute 14-2-206, our parental rights statute. Currently, parental rights are recognized in statute. However, governmental entities are generally immune from suit unless the legislature expressly creates an exception. This section makes clear that when parent rights are violated, there is accountability. It provides an explicit and narrow waiver of immunity to the specific type of violation. Page 2 amends the existing immunity statute to add this new parental rights section to the list of recognized exceptions. This ensures statutory consistency and removes ambiguity. Courts will not need to interpret legislative intent. The waiver is clear and specifically defined. This is not a broad erosion of governmental immunity. It is targeted. It is a targeted exception tied directly to violations of an existing statute. Page 3, this page addresses two procedural issues under the Governmental Claims Act. Removal of the notice requirement. Under current law, a claimant must file a written notice of claim within 2 years and comply with strict procedural requirements before filing suit. HB 157 removes that notice requirement for parental rights violations. Why? Because many parental disputes involving schools or agencies involve extended internal processes before litigation is ever considered. Parents oftentimes attempt resolution through meetings, file complaints, going through district level review, appearing before boards, and seeking administrative remedies. These processes can take substantial time. In some cases, disputes can become prolonged before litigation is even contemplated. If the statutory notice clock runs during that drawn-out process, a parent may lose access to the courts before meaningful review ever occurs. This provision ensures that procedural technicalities do not extinguish a parent's ability to seek judicial review of a rights violation. Attorney fees. Under the Governmental Claims Act, attorney fees are generally not awarded. HB 157 requires a court to award reasonable attorney fees and costs to a prevailing parent. This provision ensures meaningful access to the courts. Litigation against a governmental entity is expensive. Without fee recovery, only those with substantial financial resources could realistically pursue enforcement of their rights. This is not punitive. It applies only to prevailing parent and ensures that fundamental rights are practically enforceable. Page 4, declaratory and injunctive relief. This bill provides for declaratory and injunctive relief. This allows courts to declare unlawful conduct and stop ongoing violations. The goal is correction and compliance, not simply monetary damages. This bill does not create open-ended liability. It applies only when there is a violation of Wyoming statute 14-2-206, which is a defined parental rights statute. It does not eliminate governmental immunity generally. It creates a specific and limited exception tied to a fundamental liberty interest long recognized in law. Parental rights are among the most well-established constitutional rights in American jurisprudence. If those rights are to be meaningful, there must be a remedy when they are infringed. HB 157 ensures that parental rights in Wyoming are enforceable, not merely declaratory. It removes procedural barriers that could prevent legitimate claims from being heard and provides a narrow, clearly defined accountability mechanism. On that, I ask for your support and stand by for any questions.
Thank you, Representative McCann. Are there any questions? See, Representative Williams.
Thank you.
Chairman and Representative McCann. Remind me again, did you say the schools were cooperative with you or were not cooperative with you when you're crafting this bill? I'm not sure I heard that right. Thank you.
Representative McCann.
Mr. Chair, I guess that depends on what your definition of cooperative is. This bill, I didn't have any input from them on crafting the bill. It was mainly with the parents and stakeholders, if you will, that helped me with this. When we did send a letter, it was under my name, but several co-signers asking for a meeting to discuss this. I never received anything. I basically got a notice that I was under ethics complaints from LSO.
Thank you.
Thank you. Are there further questions? Seeing none. Thank you, Representative McCann. Would the state agency like to speak on this bill? Chief Shaner.
Thank you, Mr. Chairman, committee members, Dickie Shaner, Nishgoy Kalea with the Department of Education. Superintendent Degenfelder asked that we come here today and speak in support of this. She's been a big proponent of parental rights. And one thing that's a real challenge for her is getting complaints pretty regularly from parents and families across the state and having to continually say your recourse is your local board, your local trustees, and have to have them keep coming back and not have any other options to provide them. This would just be one more avenue for a parent or family to seek redress with a local issue. That we can answer any questions.
Thank you. Are there any questions? Seeing none. Any other state agencies? If not, we will move to public testimony. We will start with those speaking in opposition to the bill. Mr. Farmer.
Thank you, Mr. Chairman. Brian Farmer, Wyoming School Boards Association, speaking in opposition to the bill. Mr. Chairman, our perception is that current Wyoming law does provide parents rights of action. As a matter of fact, when you just passed the parental rights bill just recently, specifically in that bill, there was a right of action for parents. Parents can go to a judge and ask a judge for that declaratory relief if there is a violation of the Parental Rights Act today. If there are claims that are appropriate, then governmental claims can certainly be brought as well, and tortious claims can be brought. So Wyoming law does provide avenues existing to parents. This one is something brand new, something that was not previously a part of the fabric, and it encourages litigation. One of the things it has in there is a mandatory award of attorney's fees for a prevailing party. Whenever you're attorney, when you can get awarded attorney's fees, that's a good day. You take the lawsuit because you get that mandatory award. That takes discretion away from the judge. In most Wyoming law, the judge has the discretion of whether to award attorney fees or not. This one has the mandatory imposition. So there are a number of provisions that really just say, hey, take the lawsuit. Don't try for cooperation. Don't try for collaboration. File the lawsuit, and that is your resolution. Mr. Chairman, it doesn't provide something that isn't already there. Parents have their opportunity to go to the school district, to go to the courts. And this is really just something to encourage litigation, encourage you to do not pass on this bill. Thank you, Mr. Chairman.
Thank you. Are there any questions? Mr. Farmer, I have one. To my knowledge, we did not actually pass any private right of action. They were amendments, but they failed in the current law. Do you have a different?
Yeah,
record of
Mr.
that?
Chairman, when you passed Senate File 9 in 2024, it did include a private right of action. Now, what that is really judicial review. If a parent violates it, they take it to the judge and the judge can order specific action. What a private right of action here does is opens the door for monetary damages on top of that award of injunctive relief. So it was included as a part of Senate File 9 in 2024, where you did offer that opportunity to take it to the court for a judge to review the action of the school district and order specific performance.
Thank you. Further testimony in opposition to the bill? Please fill the chairs if you are planning to come up and speak. If they're empty, I will move on to online after this.
Mr. Chairman,
Britton.
Boyd Brown, Wyoming Association of School Administrators, Executive Director. I'm not going to waste a lot of your time. Agree with what the Wyoming School Boards Association said, Mr. Farmer. He's probably got a little more background in law than I do, so I'm not going to get into the technicalities, but we do not support this.
Thank you. Are there any questions? None. All right. None online actually on this one. Okay. Anyone speaking in favor of the bill? Mr. Winnie.
Mr. Chairman, Bill Winnie, Sublette County. And I have spent a number of years in the federal bureaucracy. And what I want to talk about here is this is parents facing down a bureaucracy. And I think it's important for you to recognize, or the committee to recognize, that bureaucracies do things because they can. You can bet that the school districts know how to use the various aspects of the law to draw things out and to wear down the parents. The parents are on their own nickel, and whether they find appropriate representation or not just kind of depends. But the bureaucrats are on the public nickel, and that's the key here, and that is how they wear you down. I support the bill, subject to your questions. Thank you.
Thank you. Any questions? Seeing none, Ms. McCoy.
Good morning, Chair, or good afternoon, Chairman, committee members. My name is Patricia McCoy, and I'm here representing all the chapters of Moms for Liberty in Wyoming. We stand in strong support of House Bill 157. Over the past few years, we've all heard the stories. We've all seen them on social media. We have spoken with friends, neighbors who have experienced serious violations and ongoing parental rights concerns. These are not abstract policy debates. These are real parents in our state, in our communities, in our neighborhoods. These parents have felt dismissed. They have felt like they have no meaningful recourse when public institutions overstep. And Wyoming has long said that parental rights are fundamental. This bill gives that principle real weight. A right without a remedy is not truly a right. It becomes a slogan. I recently heard those words spoken on the floor of the House during the introduction of this bill, and it resonated deeply, not with me, but also other parents throughout our state. This bill ensures that in Wyoming, parental rights are more than words. They're enforceable, they're protected, and they matter. House Bill 157 strengthens families by restoring proper boundaries between parents and government and by ensuring accountability when those boundaries are crossed. We respectfully urge you to pass House Bill 157 and make it unmistakably clear that in Wyoming, it truly means it when we say parental rights are fundamental. Thank you.
Thank you. Are there any questions? Seeing none, thank you. Senator Pearson.
Thank you, Chairman. Members of the board, Laura Pearson, Senate District 14. I'm not going to belabor this. Obviously, I'm a co-sponsor on this bill. I, like the bringer of this bill, sat in a meeting for 3.5 hours with parents, listening to their heart-wrenching stories of how there is no accountability in some of these school districts. This bill provides for attorney's fees and costs awarded. A lot of times these parents can't find an attorney that will take a case against the school district. This bill doesn't take into account the lifelong damage that these families have faced and are still facing, all because there's no accountability and the attitude of immunity with some of these districts. I urge your aye vote on this bill. Thank you.
Thank you. Any questions from the committee? Seeing none. Good afternoon.
Good afternoon, Chair, members of the committee. My name is Sarah Beth Nolan, and I serve as legal counsel with Alliance Defending Freedom. Parents love and know their children best. They have the right and responsibility to make decisions that are in their child's best interest without undue interference from the government. We must protect parents' fundamental right and duty to direct the upbringing of their children. And one imperative way we do that is by giving parents a way to hold the government accountable for infringing on this right. How do parental rights laws play out without a cause of action? The Perez family knows this all too well. School officials in Florida secretly socially transitioned their daughter without their knowledge, and tragically, she ended up trying to hang herself at school. The school district claimed that it had no duty to notify their parents that their daughter was transitioning at school. Florida has a very strong parental rights law, just like this state, but it did not include a cause of action. And when the Perez family sued the school for the harm that their family suffered, bearing their daughter, the school argued that because there was no express cause of action, the parents couldn't file a claim under the law. And they wrote in their brief, quote, "The legislator could have, but did not include the private right of action," end quote. This legislature has already taken steps to pass the parental rights protections in the state. And so now taking the step to make sure that they are effective is before you. I'm happy to answer questions.
Thank you. Are there any questions? I have one. How do you see the right of action in the current legislation to be insufficient compared to what we're adding with this bill?
Sure. So this would be a full private cause of action. So rather than giving discretion, the parents have access to the courts, and courts always have discretion to throw out frivolous lawsuits. That's how they manage the docket. But otherwise, it gives them a way to recover for damage appropriately. And as far as the attorney's fees that have come up as a question, that is a way to make sure that parents can afford it and that it doesn't bankrupt families trying to recover. It's very expensive litigation that takes a lot of time sometimes. So this would be fully instead of leaving a halfway measure. Right now, there's not a lot of way for parents to make action.
Thank you. Mr. Winter.
Thank you very much, Mr. Chairman and committee. My name is Nathan Winters. I'm the president of the Wyoming Family Alliance. It was a joy several years back to bring this issue to the attention of Wyoming in one of our conferences. And we were told early on by visiting attorneys that because of what they've watched in Florida and other places, unless there are some teeth, something that allow parents to find some remuneration for the issues that they are facing, really it doesn't answer the questions that rise here. And last year, I clearly recall, the cause of action that we're talking about today was extracted from the bill. And the problem is that parents often, when they go to school boards and to the courts, they are a David facing a Goliath. And that Goliath is overwhelmingly too powerful, often for them to overcome. And so this is not an open door to a whirlwind of lawsuits. I know that's how some people would want to phrase that, but you'll notice that the funds are only awarded if the plaintiff prevails. And in this case, I think it seeks a very careful balance, keeping us from having lawsuit after lawsuit. But if there is something frivolous that's brought and they're able to address it, they can find remuneration. Thank you, Mr. Chairman.
Thank you. Is there further public testimony in the room? Seeing none. Oh, this is the one with none online. We'll close public testimony. Committee, what is your pleasure? Moved by Representative Strock, seconded by Representative Lawley. Is there any discussion? Representative Lawley.
Mr. Chairman, committee, I was in the legislature when we passed Senate File 9. Been a fairly accurate description of what happened to achieve getting the bill over the line, which was taking out, probably is a good description that the good attorney from ADF gave of half measure, but it was a way to get the bill passed. The reason I support this bill and think that it won't lead to as much as you think. First of all, we've had all this time where the half measure has never been even used. But the bill itself is set up to be a structure in which the parents have some recourse. They have an ability to kind of talk and seek remedies and get information that they need. And, you know, as a litigator, I can tell you, I always told my clients that litigation should never be the first choice. It actually should be your last choice. And I had a number of reasons for that, which I won't go into because they're not that relevant. But to suggest that to add the teeth will immediately lead to that, I don't think that's true. And if it became true, I think that we might have to consider some other additions to the bill to help us work through that. But I really don't see that as a big of an issue. But I do hope it helps those conversations in the process of the bill be more meaningful. And that everybody enters in good faith to try to work out whatever the issues are. Because that's really the ultimate goal, is not to file for parents to be forced to file lawsuits. It's for the parents and the school districts to work more closely together, recognize this fundamental constitutional right that parents have, and acknowledge that might be different than the focus they understood in the past or used in the past. That is the constitutional reality, and it's actually been the reality all along. But I think we're returning to an age of parents ready to reengage. So those are the reasons I support the bill.
Thank you. Further discussion? Representative Singh? No, okay, sorry. Seeing none. Question having been called, please call the roll.
I just got excited.
This is a roll call vote for House Bill 157. Representative Braden,
Aye.
Representative Erickson,
Aye.
Representative Guggenmoss,
Aye.
Representative Kelly. Excused. Representative Lawley,
Aye.
Representative Singh.
Aye.
Representative Strock,
Aye.
Representative Williams,
Aye.
Chairman Andrew.
Aye.
Mr. Chairman, that is 8 ayes, 1 excused.
Thank you. House Bill 157 has passed the committee. House Bill 159 is now on the table for our consideration. Representative Lean.
Thank you, Mr. Chairman, and thank you, Education Committee, for having me today. Before you, we have the safeguarding personal expressions at K-12 schools. This bill aims to codify protections for student speech and expression in public schools with a strong emphasis on preventing discrimination against religious, political, or ideological viewpoints. It amends the Wyoming Governmental Claims Act to waive sovereign immunity for violations, creating a private cause of action with remedies including declaratory relief, injunctions, monetary damages, attorney's fees, and a 2-year statute of limitations from which each violation could occur. This is not new legislation. The Clinton administration put out a guidance document to the Department of Education stating that freedom of speech and prayer in school was protected. It was also passed out to the local schools among the states. This document was reaffirmed under Obama and again this month under the Trump administration. This bill codifies the Clinton administration directive reaffirming bipartisan support by later administrations. It only applies to K through 12 public schools. Private schools are exempted for obvious reasons. It prohibits discrimination and penalties against students for expressing religious, political, or ideological views in the same manner as other speech. For instance, if you were asked to write a paper on the human biology and you chose to write a pro-life paper, you could not be punished because you chose pro-life over abortion. Just one example. Schools cannot discriminate against clubs based on their viewpoints or internal requirements. Just as some schools want a Chapter USA or an LGBTQ club, this protects both and allows them all to exist. At least 10 states have similar religious liberties or viewpoint anti-discrimination acts. They're often modeled on federal regulations. There is a reference that gives us, or there is a policy at the local level that we know as fight words. It's referring to face-to-face insults likely to provoke immediate violence, which are unprotected speech. School policies typically address this in indirect through broader rules or disruptive conduct, threats, harassment, bullying, fighting, or student expression. In the county where I live, these are found under board documents 5370 and 5440. So they are already there to say that it prohibits vulgarities, disruptive dress or items. It addresses conflict resolution, and it includes harassment, sexual harassment, and is non-explicit fight words to mention, but descriptive vulgar speech tied to the dress code or violations for bullying. The equal motivation to enforce this uniformly across our school district is that cases that cannot be resolved at the local level can then go through our state courts and not through our federal courts. This is cheaper, faster, and more cost-effective for the people of Wyoming. Overall, this bill expands on existing federal precedents by providing state-specific enforcement mechanisms. It addresses perceived gaps in protections for viewpoints based on expression, particularly in religious or political speech, while incorporating safeguards against abuse. I have with me today Sarah Beth Nolan, and I will give her time for her expert testimony. Thank you.
Thank you.
I will stand for questions.
Thank you. Are there any questions? Representative Bratton.
Thank you, Mr. Chairman. Ms. Nolan, I do have a question for you on the, so actually we heard on the floor of the House, if somebody's wearing a swastika, that gives them the right to do so. I think that the bill sponsor addressed this, but would you also address that?
Sure, Chair. Great question. So the bill does not cover speech that is not already covered by the First Amendment. And anything that would be considered like a true threat, threatening a student by nature, and that child, an objective person, has a reasonable inquiry that would produce harm, then that's not covered by the First Amendment. So it wouldn't be covered by this bill. And schools still have the authority to step in where it would cause substantial disruption to the school functioning. So they're able to step in that case.
Thank you.
Thank you. Further questions? Seeing none, thank you. Would the Department of Education like to comment? Chief Shaner. Good afternoon.
Chairman, members of the committee, Nishkoy Kalea, Chief Policy Officer, joined by Chief Shaner from the Wyoming Department of Education. We're here on behalf of Superintendent Degenfelder, who is in support of this bill. The superintendent in her current role is on the UW Board of Trustees, and they have a UW Freedom of Expression initiative that has received state and national recognition. And all in all, the superintendent is very much in favor of freedom of expression and believes that this bill will further support that at the K-12 level. And we'll stand for any questions.
Thank you. Are there any questions? Seeing none, thank you. Are there any other state agencies that would like to comment on this bill? Seeing none, we'll move to public testimony. We will have 10 minutes for those speaking in opposition. Please fill the chairs. Anyone else? All three. Mr. Farmer.
Mr. Chairman, Brian Farmer, Wyoming School Boards Association. Did want to begin with, my first concern with regard to this bill is similar to the last one. I think, again, it, in our view, encourages litigation. It has a mandatory $5,000 floor for damages, the attorney's fees. I know you didn't buy that last time, so chances of you buying it this time are probably not great. But note that mandatory minimum floor. Where else in law do you have a mandatory minimum damages? Normally, that's up to the judge. The judge decides the damages. Mr. Chairman, there's a couple of other things that I'd like to bring to your attention with regard to the bill. The first of those is you heard about this disruption. Districts can step in when there's disruption. As written underneath this bill, the district can step in when that disruption is intentional and material. Intentional and material, that's a big change from what our current standard is. So we have to first determine that the disruption is intentional and that it is material in order for us to intervene. And so that's a technical issue, but that's another problem that exists within this piece of legislation. And I suppose the last thing I'd like to mention is because, frankly, I think this is a big topic that deserves more than 2 minutes of time to talk about. But imagine that this requires viewpoint neutrality. First Amendment's already protected. We don't need another state law to say, hey, under our state law, we're going to protect our federal constitution. It already supersedes it. But on that viewpoint neutrality, if somebody were to do something that is currently in violation of Wyoming law in terms of divisive concept, that divisive concept is protected under this law. And so we have to be very careful about sort of that double standard that we might be creating unintentionally. Bottom line is this is something that requires a lot more discussion. Urge your no vote. If it's something you'd like to take up in the interim, we'd invite that conversation.
Thank you. Are there any questions? Seeing none. Representative Lawley.
Thank you. Thank you for being here, Brian. I had a question, or really want to talk a little bit about the damages issue. We do in statute have what we call statutory damages, or sometimes we refer them as liquidated damages, which are in effect a minimum amount that does, the idea is it somewhat presumes a certain amount of harm if the person has made the threshold of proof. So that isn't uncommon. It's not called that here, but it functions in the same way. So if you felt more comfortable adding that language where you see something you might see in other places in Wyoming statute, but it's not unheard of, I guess is my point. I didn't know if you're familiar with that, or if you felt if we use some of that kind of language, it might help you feel better about that.
Mr. Farmer.
Mr. Chairman, I agree that there are some mechanisms that operate in a similar manner. And again, I think it's much too big of a conversation to have in a very short time frame. I think there are potential ways to have those things. But I don't think that we have mandatory minimum damages. We do have, when thresholds are met, that a liquidated damage can apply.
Thank you. Seeing no more questions, Mr. Brown.
Mr. Chairman, Boyd Brown, Executive Director for the Wyoming Association of School Administrators, again, speaking in opposition of the bill. Operationally, it is very difficult sometimes to see if somebody is being intentional. I can tell you, as a high school principal, we had kids that would wear specific clothes to get under other kids' under other kids' skin, and trying to ferret all of that out is very difficult at times. And I think this increases that burden on schools. We know that there's time and place for our students to have freedom of speech. And I think that we try to do the best job that we can there. And with that, I would answer questions.
Thank you. Are there any questions? Seeing none, Mr. Mullen. Oh, I'm sorry. Representative Lawley.
We're sorry.
I didn't.
We're operating on minimal sleep here. I think it might be actually some kind of sleep deprivation experiment that the legislature's in this moment. And I'll just say we're all at varying degrees of success or failure, however you want to measure it. But I did want to talk a minute about what you talked about concerning intent. I do understand your point. I guess my question is this. Don't teachers in effect in other areas make these kinds of judgments in different areas already? And I'm not saying it's easy because I don't think it is either. But aren't there some of this already happening, whether it's a discipline issue or who started to fight and who intended this? And I mean, some of that is already something teachers are kind of trained to do and they have to do. It's not easy. I'm not suggesting that, but I just wanted to see what your thoughts were about that.
Mr. Brown?
Mr. Chairman, Representative Lawley, it happens all the time. We have to make decisions and judgment calls. And I think having a state law that re-represents a federal law is not something that we need to do that. I think they try to do the best job that they can. And I think that it's almost an overreach for us to try to figure out exactly what the intent is at different times. And we try to deal the best that we can with the behavior of the students. And I will tell you that sometimes we probably don't get it as right as we should. And there's three sides to any story. There's the person who's doing the action, the person that the action has been done on, and then it's the story that comes out to the person that has to investigate it. And you try to do the best that you can to get in between all of those and deal with that. And I see this as just one more burden to try to overreach or reach through.
Thank you. Further questions? Mr. Mullen?
Mr. Chairman, members of the committee, Tate Mullen, Government Relations Director for the Wyoming Education Association. I'd actually like to answer Representative Lawley's question with my testimony because I think it gets to some of these other issues that are really important. So the intentional and material component of this coupled with the disruption that happens within a classroom. Now, the language within this bill actually extends further from what happened in the Tinker ruling. The Tinker ruling essentially says that, yeah, you can organize, you have the freedom to speech during, before classes, on breaks, at the end of school, but it was explicit in terms of not during instruction time. We have added that component here, and to your point in your question, Representative Lawley, do teachers make that determination? Well, given that Tinker ruling, they don't have to make that determination during instruction time. Yeah, during hallway time, recess, all of those other times, yes, they have to make that determination. But now here's another determination that they have to make during instruction time. So it's just something for you to consider because we already know that the behaviors of our students within our classrooms, they're severe, they're disruptive already, and now we're potentially adding another layer to our teachers to, hey, make this determination. Is this intentional? Is this material? It's just problematic for them. So with that, I'd stand for any questions.
Representative Lawley.
And I appreciate that. I have friends that are teachers, and I know they receive some training to try to navigate that space from some people that are experts. And I think our teachers do a pretty good job of it. But I will say that I think the reason this goes into the classroom is because one of the places some students feel inhibited to share their viewpoint is when maybe the teacher has a really strong viewpoint and isn't really open for an actual debate, for critical thinking, for all the things we know we want our kids to do. And I'm not sure there's any other way to enter that space and say, we need to make sure that all kids are welcome and to some degree in some period of time as they enter into a discussion to share their viewpoint without any sense of retribution, punishment, whether it's in a grade or some other way. I think that's usually what some students have experienced. And, I have a granddaughter in high school this year, and there are just times they feel like maybe the teacher isn't open to maybe a different point of view. And then there are other teachers that are honestly very good at wanting that engagement and for critical thinking. So I think that's what this bill is trying to aim at, is that renewing and restoring that sense of why it's so important to hear different viewpoints and understand that we don't have to agree. We just have a space we can share and think about each other's the different viewpoints. it helps our students. It sharpens their thinking. Sometimes they see and hear things that they never thought of. And so that's what I see this bill trying to do. I understand it to do. And I understand the concern about teachers, but I really think the value here so is something that I think, and I actually think teachers can learn to navigate it if that's what's valued. If that's what, we say, hey, we want these to, especially in the upper grades, these viewpoints to be shared. When we enter a subject, we have a period of time where they can go back and forth about their view on that. So I think it's strong, and I would love your thoughts on that, because I know this is difficult, but the question is, if something is really important and we can help teachers and train teachers towards engaging in this way, shouldn't we?
Mr. Mullen.
Mr. Chairman, Representative Lawley, I agree completely. We absolutely, like some of my best experiences in the classroom, whether that was either teaching or whether that was as a student, and we had talked about this previously, debate courses or those courses that required you to argue a viewpoint that wasn't yours, right? So being exposed to different ideas and different beliefs, all of that is incredibly important in shaping our young minds, and we value that. And I haven't yet met a teacher that doesn't value that. That being said, I think one of the things that I would say is that we've got those in place, again, to the point where we've got federal protections in terms of our First Amendment rights. Those exist. We have those. And same when it comes to what our students can say and what they can produce in an assignment, in a discussion even, right? Because really what we're hinging on is this disruptive piece and whether that's intentional or material. But I would also, one other piece here, I also don't want this to be a carte blanche like excuse to maybe mess up an assignment but expect a good grade. So maybe a horrible example here, right? So if the topic is, say, the events leading up to the Constitutional Convention, I doubt a thorough citation of Mao's Little Red Book is probably an appropriate citation. So we wouldn't want to see that, right? So and there's language in the bill that is, it's the same that we've seen in case laws that, you still have to grade those assignments and those things on the merits that, you develop a rubric and do that thing. But I just want us to be very careful. But at the end of the day, I absolutely agree that our schools are a great place to foster wonderful ideas and a diversity of ideas. And I don't know of a teacher that does not adhere to that belief. So.
Thank you. I think we have one more question, Representative Erickson.
Thank you, Mr. Chairman. Excuse me. I really think that this bill and this bill idea has moved a long ways, but I wanted to ask kind of everyone involved that's testified so far. I'm a big fan of, in this particular case, looking to get more clarity through an interim topic. I think that we're on the verge of something really good, but I also think because of national events and things that are going on and the landscape is changing drastically, that this would be a perfect opportunity for that. So, would you feel the same, or where would you head in this direction, or in general direction, possibly besides just killing the bill or moving the bill forward? I mean, other options.
Mr. Mullen.
Mr. Chairman, Representative Erickson, I think it'd be a great topic for the interim. I think it allows for a diversity, the very thing that we're talking about, of viewpoints, and get everybody's voice in the room and have a good discussion about how we can actually make this work effectively for everybody involved. So we'd welcome an interim on this.
Thank you. We'll now close public testimony for speakers in opposition, and we will take public testimony for in support of the bill. Ms. McCoy.
Good afternoon, Chairman, members of the committee. My name is Patricia McCoy, and I'm speaking on behalf of Moms for Liberty Wyoming. I'm here today in strong support of House Bill 159. This bill addresses something simple but deeply important: fairness. Students in Wyoming public schools should be free to express their religious, political, and ideological views without being treated differently because of those views. House Bill 159 establishes clear protections so that students can speak, organize clubs, and participate in school life on the same terms as their peers. It ensures that student groups are not singled out because of their beliefs and that policies are applied consistently across the board. Recent events in Natrona County involving a student's attempt to start a Club America chapter have brought this issue into sharp focus. When students perceive that the rules shift depending on viewpoint, it creates confusion and distrust. Students should not have to navigate political headwinds simply to participate in lawful student-led activities. Schools are meant to prepare young people for citizenship. That preparation includes learning how to express ideas, organize around shared interests, and engage respectfully with differing perspectives. Those lessons lose their meaning if some viewpoints are quietly discouraged while others are welcomed. This bill provides clarity and consistency. Wyoming has long valued free expression and civic engagement. This bill ensures that those values are reflected inside our schools as well. Moms for Liberty respectfully urges you to pass House Bill 159 and ensure that every student, regardless of viewpoint, is treated equally under the rules. And if I may answer Representative Erickson's question that he'd like to ask others, I would like to do that as well.
You have a little bit of time left.
Thank you. Representative Erickson, I would not put this to the interim. This bill would have protected 3 of my 4 children and 3 different situations in one school. One child was told that he could no longer pray before his basketball games with his teammates. One child was told that he was not allowed to wear his sweatshirt that said, "If you are feeling depressed or anxious, call on Jesus." My 3rd student was punished because he refused to do an assignment the way that it was instructed to. Please evaluate and state why Martin Luther King Jr.'s speech incited hate, violence, and division across our country. His speech was to bring people together, and that is what my son wrote, and he was punished and failed that assignment for it. Thank you.
Thank you. Are there any questions?
Mr. Chairman.
Representative Erickson.
Yeah, just real quick. I appreciate your testimony, no doubt about it. You've had some amazing experiences over your education, your kids' educational. It happens fast and furiously, it seems like. That's interesting. Do you think other districts would react the same? I mean, I know we're all aware of the Natrona County situation, but I'm talking Western Wyoming again. I have to come from that perspective a little bit because that's who I hear from primarily. Would they feel the same, or is this kind of isolated cases? Is it, in your opinion, rampant, or just you've had some bad experiences? Or tell me about that.
Ms. McCoy.
Thank you, Chairman. To you, Representative Erickson. I sure have. I'm a very involved mother, and I have been since grade school. So I've had plenty of excellent experiences as well that don't pertain to the bills that we're discussing. With the parents that we have spoken to across the state, yes, I would say that parents on the western side, the northwestern, northeastern would all also agree. We have seen other instances in schools in other areas, not just Natrona and Cheyenne, where this is happening. And so that is why we are speaking on behalf of all the chapters today.
Thank you. Representative Singh.
Thank you, Mr. Chairman, and forgive me, my brain is a little foggy. We were here 12 hours ago. We're gonna be here in 12 hours, so it's gonna be a great day. So a couple of, and I think it was a couple of days ago, there was a large body of young people that made their way to the Capitol building to voice their political beliefs, and I didn't hear what they had to say. I saw some of the trash that was left around afterwards, but would this bill apply to a situation like that where young people are trying to express themselves? Does that have anything to do with what we're talking about, do you think?
Thank you, Chairman. Representative Singh, I do not think that that would apply because that is more of a protest than a club in a school assignment, clothing that a student is wearing. I feel that that is what this bill addresses more firmly, and that would better be protected under the First Amendment of the United States Constitution.
Thank you.
Thank you.
Mr. Winnie.
Mr. Chairman, Bill Winning, Sublette County again. This bill, like the previous bill, is about parents taking on a bureaucracy. Bureaucracies have wonderful ways of putting their finger on the scales when they want to do something. And it's your job to ensure parents have the ability to take on bureaucracies when that is appropriate. I'm a graduate of the U.S. Naval Academy and a noted author and commentator that I pay attention to. Served as a visiting professor at the U.S. Naval Academy for 3 years. And one of his comments from that experience at the time he was there some years ago was that wokeism had infected the faculty of the U.S. Naval Academy. Well, this is the kind of thing parents want to take on, and they need the ability to take it on. And that's not always there. I know what it's like to sort things out. I was an Article 15 hearing officer for 5 years of my time in the Navy, and probably heard 700 or 800 cases. I led major investigations, so I know what it's like to go out there and try and fact find and things like that. And then finally, as a parent taking on a public school system, I served 2 years on the island of Guam way out in the Pacific. If you want to see how big the Pacific is, take a flight to Guam. The first year we were there, we had our children, 3 boys in public school system, and we were not happy with it. My wife is a career educator, and so we pulled our kids out of the system and homeschooled. In one case, we put our eldest boy in a Catholic parochial high school. We're not of that faith, but it was the best choice at the time. On leaving the island of Guam after my full 2 years, I wrote a letter as commanding officer of the USS Holland, crew size about 1,500. At the time, biggest single command on the island of Guam, about our experience there. The upshot of that letter was the Department of Defense came in and set up a DoD school system and pulled all DoD children out of the public school system and put them in the DoD school system. And so giving parents the ability to do that, my letter that I wrote would not have had the impact it had if I hadn't been commanding officer of the largest single command on the island. Giving the parents those tools is what is, I believe, to be your job. Subject.
Oh, you would.
I just subject your
finishing. That
questions.
was
Thank you.
Good timing. All right. Are there any questions? Seeing none, thank you. Is there any further testimony in support of the bill? None online. All right. We'll close public testimony. Thank you. Committee, what is your pleasure? Moved by Representative Strzok.
I was going to motion to table, but she beat me.
Oh, good job. I'm faster than you.
Yeah. Well,
Do we have a second?
I hit my mic.
Seconded by Representative Guggenmoss. Is there any discussion? Seeing none, all those in favor of, no, we're not doing it that way. Please call the roll.
For clarification, this is a roll to table.
No, sorry, this is a roll to vote on.
Question on the bill.
Yeah, question on the bill.
This is a roll call vote for House Bill 159. Representative Braden,
Aye.
Representative Erickson,
No.
Representative Guggenmoss,
Aye.
Representative Kelly is excused. Representative Lawley,
Aye.
Representative Singh. Aye. Representative Strzok,
Aye.
Representative Williams.
Aye.
Chairman Andrew.
Aye.
Mr. Chairman, you have 7 ayes, 1 no, 1 excused.
House Bill 159 has passed the committee. House Bill 178 is now on the table for our consideration. Representative Williams.
Thank you, Mr. Chairman, members of the committee. J.D. Williams. I'd like to I insist actually on being here to present this bill. I understand there's many here that have strong opinions on this bill that will also be presenting from this table. And so I'd just like to encourage all my fellow committee members to give me no latitude. And I really need we really need to flesh this out. I appreciate your critical analysis of this bill. For your information, I will recuse myself from voting on this bill when deliberation here is over. House Bill 178, public unions transparency and dues withdrawal limitations, protects individual choice and worker freedom in relation to public sector unions. The bill ensures public employees maintain full control over their own earnings. It prevents the state from automatically collecting dues or political contributions on behalf of unions. I'll go through the bill just a little bit here on page 2. Lines 2 through 21 is the central provision of the bill, which prohibits public employers from using public funds or facilities to deduct union dues. It's important to note this legislation does not prevent or stop anyone from voluntary association. If a public employee wants to join a union, they're fully capable of doing so. The only difference is if this bill is enacted, the state will not be involved in that transaction. On page 3, lines, the whole page, page 3 and page 4, all the way down to line 18, is a part of the bill that deals with transparency and accountability, and it requires the union, public employee unions, to prepare an annual report, and it gives a list of metrics there that they need to report, including how many employees they represent, how many of those are paying members, and spending on political activities. Page 5, lines 1 through 8. Where it speaks about where these reports must be shared, published on the union's website, provided to anyone upon request. That's page 4, lines 20 through 23, and page 5, lines 1 through 8, excuse me. And page 5, lines 10 through 15, exempts unions that already file federal form LM-2. Page 5, lines 17 through 23, and going on over into page 6, lines 1 through 3, speaks about violations of this act. And page 6, lines 4 through 23, and on to page 7. This bill explicitly states it does not authorize new collective bargaining obligations. It does not impair firefighters' bargaining rights. It does not prohibit employees from making direct voluntary payments to a union or associated political funds. And I will I'll look at that a little closer there. That's on page 6. G, if we look at G on line 4 there and go down to Romanet I, It's not legalizing collective bargaining in that section. And likewise in Romanette II, they're on line 10 on page 6. It references a Wyoming statute, that's employee ethics statute. And when we read that statute, it aligns with the intent of this legislation. Romanette III on line 13, it references another statute. That's Wyoming's right to work statute. And then line 17, it makes it clear that nothing impairs the right of the firefighters to collectively bargain. And it references those 2 statutes that apply to firefighters. I appreciate your time. I appreciate you hearing my bill. And I believe this bill strengthens individual choice. It reduces government facilitation of union funding and promotes greater transparency in how union dues are collected and spent. I believe that's a benefit to hardworking citizens of Wyoming. And I'll stand for questions.
Thank you. Are there any questions? Representative Erickson.
Help me out just a little bit. Thank you, Mr. Chairman. Representative Williams, who does it apply to then? I mean, who now is in the narrow focus? You removed the firefighters, you said?
Well, they're already removed, Mr. Chairman, Representative Erickson. They're already removed under Wyoming statute. Okay. Just it just moves the responsibility from the state to do the collecting to where it's a personal choice. It is it removes the responsibility from the state employer to be the accountant to collect union dues. Does that help? Thank you.
Further questions? Seeing none. Would the Department of Education like to comment on this bill? Thank you, Representative Williams.
Good afternoon, Mr. Chairman, committee members, Dickie Shaner, Nishkoy Kalea, the Department of Education. Superintendent Degenfelder asked us to come here and speak today in favor of this bill for 2 primary reasons. One, it's just good policy to separate government employers from the funding of labor organizations. And then the second is that since this is government employees and taxpayer dollars involved, the added transparency in this bill is a helpful thing. So with that, we'd be happy to answer any questions.
Thank you. Are there any questions? Seeing none, thank you. Are there any other state agencies that would like to comment on this bill in the room? Seeing none, we'll open it up to public testimony. We'll start with those in opposition to the bill. Please fill the chairs. Good afternoon.
Chairman Andrew, members of the committee, my name is Marcy Kindred. I'm the Executive Director of the Wyoming State AFL-CIO. I spend 20 to 40 days a year in this building advocating on behalf of our members, the hardworking people of this state. The rest of the year, I handle the boring administrative duties like taxes, reporting, management and maintenance of our building, working with agencies, but I also do great stuff like working with agencies and union leadership on solutions to address worker issues like Wyoming's workplace fatality rate, the highest in the nation, communicating with our membership and supporting the men and women across Wyoming who build, teach, protect, and serve our communities. My salary, my time here, my family's healthcare, and contributions to my union pension are all funded by the very thing we're here to discuss today. Voluntary payroll deductions. And while I'm sure there are some in this building who'd rather it didn't, I bring it up to emphasize that I am not a corporate lobbyist. I am not here at the behest of a national think tank. My time here is on the dime of the hardworking people of this state that keep it running. Monetary contributions they voluntarily choose to have deducted from their paychecks. HB 178 singles out public employees and removes a voluntary paycheck choice that every other Wyoming worker has. It doesn't touch any of the other payroll deductions, retirement, health insurance, religious tithes, none of it. It targets one deduction for one group of Wyomingites. Wyoming's firefighters are one of our own, a direct affiliate. The first ones on the scene on your worst day, the people who run towards danger while everyone else is running away. They are among the workers this bill targets. And I think there might be a question in the bill text. It clarifies that this does not affect the firefighters' collective bargaining. That is a separate issue, and that's a clarifying piece. That does not exempt the firefighters from this. They are still very much in the bill as written. But the people here, sorry, just a note on that. I want you to look around this room. We've lost some, but I promise you, we had a rotunda full of Wyoming workers at noon today. Many dropped in on their lunch breaks and had to go back to work. But the people who came to show up against this bill weren't just here to defend their own paychecks. They were here to defend the principle that the government has no business telling any Wyoming worker what they can and can't do with the money they've earned. And the text of this bill also references the cost of administrating these deductions with public funds. Throughout my career, my employers have administered voluntary payroll deductions, 401ks, deposits into different accounts, savings, checking, healthcare premiums, life insurance, debt payments, and tithing. Once a payroll system is set up, adding an additional deduction takes about 2 minutes of typing in an account number during onboarding. The ongoing cost is virtually zero. I would be very interested to see the cost analysis comparing that minimal overhead to the new administrative burden and reporting requirements that this bill would create.
Thank you for your testimony.
Yeah,
Thank you.
those are the
It'll take
points.
A few seconds to wrap up. That's okay.
Yep. That's you.
Okay.
We're on the same page. That's all I got.
All right.
Yeah.
Thank you. I've done that twice today. So
it was good.
All right. Thank you. Who's here first? Good afternoon. Whoever would like to go.
Mr. Chair, members of the board, my name is Dylan Ford. I'm a teacher here in Cheyenne. I can tell you guys are tired because you remind me of my first period class. Sorry. I'm a proud member of the Cheyenne Teachers Education Association, and what our little education union does. We negotiate safer, healthier conditions for our students and our members. We negotiate for higher wages and better benefits for our members and their families. We advocate for policies that improve student outcomes and well-being. We do good things. This bill, however, is an attack on that work, and frankly, it's an attack on our members. Our members really like payroll deduction. It's convenient. It's a choice that they get to make. So what right would a conservative government have to make choices for individual people? Why not let local control come into play here and allow districts to choose for themselves and allow members to make that choice for themselves? This removes a choice. It doesn't protect a choice. The other side of this bill calls for transparency, and I can see the concern. It does seem like there's too much dark money flowing around the Capitol, coming from too many unknown people and organizations. But if we're going to call for transparency, let's call for transparency for all political donors and organizations working and influencing here at the Capitol. As it stands, this bill only targets the common man, and multimillionaires with deep pockets are left out. The common man, the working person, that is what unions have always stood for. To quote the definition of this bill, unions are organizations that, quote, exist for the purpose of dealing with employers concerning wages, hours of employment, or conditions of work. So why attack unions? The only reason is in that definition. It's to attack the common person's wages, hours of employment, and conditions of work. I ask that you vote against this bill in order to support the workers of Wyoming. Thank you.
Thank you. Are there any questions? Seeing none, Mr. Mullen.
Mr. Chairman, members of the committee, my name is Tate Mullen, Government Relations Director for the Wyoming Education Association. Wyoming values hard work and great work ethic. The folks that this bill targets are the salt and earth, the folks that do that work. Teachers, public employees, firefighters, they embody the value of hard work and work ethic. In Wyoming, we also value freedom. The value of freedom extends to how we, the hardworking folks, spend their dollars that they have earned from their labor and their services. Inversely, we also value the freedom from big government. We are Wyoming. We do not like big government, especially in the form of telling us how and where we can spend our dollars. Again, our members self-select into this. This is not something that we're just out there grabbing dues. I do want to reiterate, what's good for the goose is good for the gander, right? This proposal unfairly singles out folks like the public employees, teachers, yet allows big money special interests like insurance companies, big banks, financial companies, and other political organizations to spend heavily on lobbying and politics without any of that transparency that you seek from these organizations. Let's get back to the issue of big government. On one hand, it eliminates dues deduction, but then proposes to mandate to non-government organizations to provide information. This is the embodiment of big government. This is not a Wyoming value. I ask you to vote no.
Thank you. Are there any questions? Thank you. Let's see. All right, please fill the chairs. Good afternoon.
Good afternoon, Chairman and members of the committee. My name is Kim Amon. I'm president of the Wyoming Education Association, and I ask you to vote no on this for all of the reasons that have been stated. Especially, I'm very confused on trying to eliminate payroll deduction to separate the government from the worker and that the state should have no say in that, but then requiring the transparency in the bill and requiring all of the reporting that goes along with that doesn't make sense to me. If you're trying to separate it, why should a private entity have to provide that information? And what I heard was that that information is because we're being paid by tax dollars. But I want to make sure that you all understand that public employees provide a service for that money. We are workers. We are common workers. We are the people who take care of your children and teach them during the day. We are the firemen who came to my house and stopped the fire behind my house a couple months ago to save our homes. We're the laborers. We're the people who keep your cities going. So why should we have to provide transparency on how I spend my money? I choose to spend my money that I've earned because I've provided a service back to the city of Cheyenne and back to the state of Wyoming. I ask you to vote no. Thank you.
Thank you. Are there any questions? Seeing none, good afternoon.
Thank you, Chairman Andrew, members of the committee. My name is Kevin Reddy, and I proudly serve as the president of the Federated Firefighters of Wyoming. I represent most of the career firefighters across the state, and we respond to the majority of the 911 emergency calls that the citizens of Wyoming make. And as a note, we've lost 13 of our members in line of duty deaths in service to the citizens of Wyoming. I currently work as a 24-year member of the Cheyenne Firefighters, where I work as a lieutenant. Rise today in strong opposition to House Bill 178. We have several concerns over our voluntary paycheck deductions that firefighters make on an individual basis to support union dues, union PACs, and union charities. And this bill would disallow our employer, who has already chosen to offer paycheck deductions as a benefit of employment for all sorts of a variety of different reasons. When you look at some of those paycheck deduction options, we have things like Wyoming Retirement System 457 funds, which are voluntary paycheck deductions offered to our members. AFLAC supplemental insurance. These are voluntary services that a member can purchase. And the firefighter unions, much in the same way, our 457 funds provide financial security later in life. AFLAC provides insurance for unseen disasters that happen in our members' lives. But the employer is not mandated to remove those fees for those services to the firefighters. They have to pay those and with consent, give permission to the employer to withdraw money from their paycheck. Union dues, union PACs, and union charities are no different in that regard. There is a major difference, though, in the Wyoming 457 funds and the AFLAC in that those services provided are only provided when a member pays fees. Firefighter unions are not mandated, cannot force members to pay dues because they're a firefighter. That would violate the 1963 Wyoming Right to Work law, and it violates the 2018 Janus decision in the United States Supreme Court, where all public employees are right to work. But our firefighter unions have to give all members of the bargaining unit full union services, whether they pay dues or not. Further, when you look into the bill, there's a prohibition on the union use of facilities. The International Association of Firefighters, the Federated Firefighters of Wyoming, provide extensive training in hazardous materials, technical rescue, wildland urban air interface, and mental health issues that affect firefighters. And this bill has some concerns with that. And likewise, I'd repeat the.
Thank you. Sorry, it's been 2 minutes. You
All
can
right.
wrap up
Thank
quickly
you.
if you'd like.
Again, I would urge a no vote on this bill. Let the firefighters choose what associations they want to associate with and how they pay for them.
Thank you. Representative Lawley.
Thank you, Mr. Chairman. Appreciate your testimony. Can you explain to me on page 6, where it talks about impair the rights of firefighters to collective bargain as provided by and there's a statute, actually, a section of statute there. What in your mind does that mean to you? Like, I'm asking a genuine question. Like, what does that cover? Because I think someone raised earlier that that's not sufficient, and I think they might be right, but I want you to tell me why that isn't sufficient.
Mr. Chairman, Representative Lawley, at the risk of talking law with a lawyer.
That's okay.
So the firefighter collective bargaining rights, when we look at those statutes, they clearly say they have terms of the employers, which are the corporate authority, and they have terms for firefighters. There's nothing in here about public sector unions in the bargaining statutes. But in this proposed bill, under the definition of public sector union, the International Association of Firefighters and our local affiliates here in Wyoming absolutely qualify under that definition. So I'm not seeing how this does not, or I'm not seeing how we're carved out in any way in this proposed legislation. This absolutely will be a detriment to our members.
Follow up.
Representative Lawley.
Thank you for that. Thank you, Mr. Chairman. What in your mind, if our desire was to exempt you, what kind of language would, I'm not saying whether it's good or bad, I see the head shake going on back there, but that's not really my question. If our desire was to exempt you, what type of language, and maybe there's someone else that can address that, would be adequate to accomplish that in your mind?
Through you, Mr. Chairman, Representative Lawley, I can't speak into the specific legalese. I guess I struggle. I mean, this bill is aimed directly at public sector unions, and we are a public sector union. And there's some odd language in the definition of an employer, where apparently our cities, towns, and counties that are our employers are no longer considered public employers in the terms of public safety. So I don't have like a draft language as far as a carve out.
That's okay. Thank you. That's good enough. I'm just wondering.
Thank you. And we're out of our 10 minutes for public comment. If you'd like to summarize your comments in 30 seconds or so, I think we'd have time to hear that.
More than amenable to that. Thank you, Mr. Chairman, members of the committee. Jonathan Brown, Wyoming Public Employees Association. Just briefly wanted to touch on stand in support of everyone who's spoken in opposition previously, echoing their concerns. Going off of the firefighters' point previously, we also have roughly about 8 insurance plans that we offer to all of our active and our retired members as well, which can cover them, their spouses, and any dependents that they might have. And so our concern mainly in regards to the bill is getting rid of payroll deduction requires us by July 1st to be able to make sure to set up an apparatus to collect dues to ensure both the health of individuals and their insurance plans, but also the health of plans that we get as an entity on its own. Because if not, if we're a failure to provide those coverages, we're unable to provide dental, vision, identity theft, and legal shield, a variety of different coverages, as well as our accidental death and dismemberment for all of our active and retired members. Thank you, Mr. Chairman.
All right. Is there any testimony in support of the bill? Ms. McCoy.
Thank you, Chairman, members of the committee. My name is Patricia McCoy, and I am here representing all of the Wyoming Moms for Liberty chapters. We stand in support of this bill. Right now, public school districts, which are funded by Wyoming families' hard-earned tax dollars, process automatic payroll deductions for union dues and political contributions. That means the same system that issues taxpayer-funded paychecks to teachers is also being used to move money into private labor organizations and political activity. Taxpayers have no voice in how those political dollars are ultimately spent. In fact, many families have watched union leadership promote policies, agendas that run directly counter to the values of parents across Wyoming. Even more concerning, we have seen unions use these financial resources to sue the very state that funds our schools. So the people paying into the system are in effect helping finance efforts that work against their own interests. To many families, that feels like being required to supply the fuel for a machine that is actively working against you. The infrastructure they pay for is being used to power political advocacy they neither control nor consent to. House Bill 178 restores a necessary line. Public systems should serve public purposes. They should not be positioned, even indirectly, to operate against the very citizens who sustain them. Public schools exist to educate children. Payroll systems exist to compensate employees. They were not designed to serve as financial conduits for lobbying, campaigning, or organized political influence. When a government paycheck becomes the vehicle through which private political funding flows, the distinction between public service and political machinery becomes harder to see. Even in participation is voluntary, the infrastructure being used is publicly funded and publicly administered. And House Bill 178 restores that boundary. This bill does not prohibit union membership. It does not prevent any teacher from supporting a labor organization. It also strengthens transparencies so members can see clearly
Thank
how
you,
funds are
Ms.
collected.
McCoy.
Thank you.
Sorry, we're out of time. Are there any questions? Mr. Halverson.
Mr. Chairman, members of the committee, thank you for the opportunity. My name is James Halverson, Deputy State Director with Americans for Prosperity right here in the Cowboy State. I spent 15 years as a high school educator and coach. During that time, I was a member of many organizations, the National Association of Agriculture Educators, the Wyoming Association of Agriculture Educators, the Association of Career and Technical Educators, the Wyoming Association of Career and Technical Educators, coaches associations, and many others that I don't have time to list right here. None of those organizations were afforded the privilege to touch my paycheck before it hit my bank account. They just didn't have that privilege. So why are we playing favorites here? I was able to be a part of those organizations. We could have them auto draft that from my checking account. I could take them a check, whatever. That was my business. And we just think this is a flaw in the system that, quite honestly, we're pretty lucky hasn't been exposed just yet, because how many organizations would it take for this to start actually costing the state serious time and money? So we think this needs to be fixed. Furthermore, on the transparency part, as a member of those organizations, I think as a young member, that would have been very helpful, probably would have been very engaging and helped me be more motivated to be engaged in those organizations had they been more transparent. So we think that's probably a good thing for the organizations. And that concludes my testimony. I'll stand for any questions.
Thank you. Are there any questions? Representative Bratton.
Thank you, Mr. Chairman. I do have a question. I had a question about this whole section. Like who else has to do all this, collect all this data and do all the reporting?
I guess I'm not 100% clear. I mean, the state has to, what we're trying to get here is the state out of taking those automatically out of their payroll. So
Representative Bratton.
Thank you. I'm more referring just to reporting who belongs to the organization and all that information.
Mr. Chairman, I'll give a quick comment and probably defer to my colleague here. I would believe that would just be the unions themselves.
Thank you.
But
Thank you. Further questions? Mr. Daughtry. Doherty.
Mr. Chairman, members of the commission, thank you so much for the opportunity to appear. I am going to use some of my time to tell you thank you for the efforts you put in last night and those that you'll put in again tonight. The amount of effort and energy you put into this is not lost on me. So I know that's time I won't get back, but it was important to me. So I want to talk. I was surprised by some of the testimony. First of all, I'm Jeff Daugherty. I'm here representing the Freedom Foundation today. I am not a hired gun. I represent organizations that I ideologically believe in. Those of you who know me know I used to work in K-12 as an assistant superintendent. I have 4 members in my immediate family circle who are firefighters. So if they thought I was here to attack firefighters, Thanksgiving would be super awkward at my house. I am not here to go after any employee association. I think they do great work. What I am here today is to say that it is not appropriate to use government resources for funding private and public union dues. Like those are taxpayer dollars that are accounting for those, monitoring those, remitting those funds, and it's not an appropriate use. And I don't care if the purpose was for conservative purposes at the end of the day. It is not an appropriate use of government resources to fund political activities and union activities within the organization. But I will tell you that what we're talking about here today, I've heard the word attack a lot, and I want to tell you what we're talking about. We are talking about having to fill out a 1-page to 2-page sheet of paper that says in fact, the very sheet of paper that you use to have payroll deductions made to these existing organizations. And instead, you will go to your bank and have them do an ACH transfer. It is also a 1 to 2-page sheet of paper. So it is not a horrible burden on the employees. It doesn't mean that we don't appreciate firefighters or teachers or anyone else. It simply means we need to keep it clean and it needs to move outside, and it needs to be a private contract between these organizations, these employees, and whatever activities they choose to engage in at the end. Representative Bratton asked who else has to report. According to the information that you have in front of you that I provided just before the meeting, that my client provided, presently, to my knowledge, private entities do have to report how they're spending the money. Presently, public entities do not have to report how they're spending the money.
All right, thank you.
And so,
Thank
thank
you.
you, Mr. Chairman.
Thank
Happy
you.
to answer questions.
Are there Representative Lawley?
Thank you, Mr. Chairman. Thank you, Mr. Doherty, for being here. Good to see you. Do you have any estimates on, you talk about the government costs of doing it. Do you have any information on that about what, so much of this is automated, I assume, but I'm just trying to understand to weigh that, what are we saving? What do we, I understand some of the other arguments, but on this issue specifically about it's government employees, it's government, what actually happens right now without this bill?
Mr. Chairman, Representative Lawley, that's a fantastic question. And while I can tell you that earlier in my career, my responsibilities were to manage the functions within the school district that handled that, we didn't track the exact amount of time that we spent on it. But I will tell you that I think if you speak with business managers around the state in school districts, they'll tell you that it is certainly nowhere close to the majority of their time, but it is time that they have to spend accounting for these funds, monitoring these funds, having funds audited at annual intervals. And so there is effort that's involved. And my point is, any effort is too much effort in this regard. It should be separate and private.
Thank you. Further questions? Seeing none, is there further public
Thank you.
testimony in support of the bill in the room? Seeing none, we will go online. Who do we have? Who's ready?
I will promote Maxford Nelson, who has their hand up still, to panelists. They should be in the room in just a second.
All right, thank you. Good afternoon.
Good afternoon. Am I coming through all right?
You are.
Excellent. Well, again, good afternoon, Chairman Andrew, members of the committee. My name is Max Nelson. I'm Director of Research and Government Affairs for the Freedom Foundation. We're a 35-year-old nonprofit organization which works to promote individual liberty, free enterprise, and limited accountable government in states around the country. I'm very sorry I couldn't be there to join you in person today. Business has me tied down in Idaho this week. Just a brief note on my personal background, since I know I'm a stranger to the committee. I've worked on labor policy issues and labor unions and collective bargaining as an expert for the Freedom Foundation for nearly 13 years. I have a certificate in labor relations from the University of Wisconsin. And during the first Trump administration, I served as a presidential appointee to a component of the Federal Labor Relations Authority. We are here in strong support of House Bill 178 for two reasons, some of which have been articulated. First, we believe it makes unions representing public employees in Wyoming more accountable to taxpayers. And secondly, we think it makes them more accountable to their own members. I think there's some important misconceptions that I'd be happy to address about what the bill does and doesn't do. To revisit the question of how or whether firefighters in the state of Wyoming are affected, I would draw your attention to two components of the bill, one of which has received some discussion already. On page 6 of the bill, line 17 through 19, as has been noted, it provides that nothing in the legislation shall impair the right of firefighters to collectively bargain, as is their right pursuant to a separate section in Wyoming statutes. That is my understanding. That is the only authority that provides, or potentially even provides, for those entities that employ firefighters to engage in payroll deduction of union dues, as if it's collectively bargained by the union in their contract with their employer. So by specifying that their full scope of their collective bargaining rights is not impaired by this legislation, I think that in and of itself is sufficient to carve them out. But the bill takes a belt and suspenders approach to this issue, and I would note that all of the prohibitions on payroll deduction that you see in Section 1 of the bill apply to public employers as the term is defined. So if you go to Section 2 of the bill, page 8, lines 4 through 9, the term public employer specifically excludes, does not include, a corporate authority as that term is defined in this Wyoming statute 2710-101. And if you'll turn to that statute,
Time limit.
Well, I appreciate your time. Happy to answer questions if you have any.
Thank you. Are there any questions? Seeing none. Thank you. We went over before. We have one more online. Is Ms. DeCero with us? She's not. Okay. All right. We will close public testimony with that then. Committee, what is your pleasure? Moved by Representative Strock, seconded by Representative Guggenmoss. Is there any discussion or amendments to the bill? Representative Bratton.
Thank you. I would like, I'm going to propose an amendment on page 2, line 5. A period after the word fundraise. So it'd be no, and that is getting back to the issue of fairness, and is this just going to apply to the labor organization? So that would just say facilities to support or fundraise, period. So no public employer, nor its agents or representatives or any person acting on behalf of the public employer shall use or authorize the use of public funds or facilities to support or fundraise. And then, as you can see, going down to line 8, it talks about what, can be deducted. And of course, the labor organization is included in there, but so are political action committees, political organizations, political committees. And after this amendment, I will make another amendment separate to add any candidate for federal, state, or local office, but that will be a separate amendment.
Okay, do we have a second on the amendment?
I will second that.
Seconded by Representative Singh. Any discussion? Seeing none? Oh, a question. Okay, sorry. All those in favor of Representative Bratton's amendment, say aye.
Aye.
All those opposed, no. Representative Bratton.
Thank you. I'd also like to have an amendment to add at the bottom of page 2, underneath D, add an E. To add, this would also apply to any, probably don't put also apply, but any candidate for federal, state, or local office. To add any candidate, we're going to add any candidate for federal, state, or local office as an E underneath D, political, following political committee. So it would also apply to us.
Am I able to read back that language just to make sure I got it down?
Yes, please.
Yes, sir.
So on line 22 would be adding a subsection E, just saying any candidate for federal, state, or local office.
Correct. Thank you.
Is there a second? Seconded by Representative Guggenmoss. Is there any discussion? Seeing none, all those in favor, say aye.
Aye.
Aye. All those opposed, no?
No.
The amendment is adopted. Further discussion, Representative Lawley.
I still have some concerns on the bill that we just haven't quite got it right. And I don't know really how to fix it, to be honest with you. So at this point, I'm probably going to be a no, but because I just don't know quite how to fix some of the concerns of who's in and who's out, and whether the same justification applies for some that are out, and should they be in, and those kinds of things. So I just not certain how to fix that right here, right now, with the amount of sleep, 2 hours I've had in the sleep deprivation experiment we're in. So I just, sorry, but I'm not making light of it. I just really don't think I know quite how to handle that. I actually think trying to fix it will make it worse legally because of that. And so, again, just to be honest, I have some concerns about who's carved in, who's carved out. Does it fit? What is the purpose? I mean, what we're trying to accomplish if we've left big chunks out? And so, and will that result in a legal challenge is my point here. I'm curious about it sort of just generally, but more about how this bill would be subject to legal challenge. And we haven't spent enough time talking about that. And I don't think we even have the right people in the room to have that discussion. And so I'm not necessarily opposed to the idea of the bill. I'm just not sure this gets us where we think it does. And I'm really concerned about some legal liability.
Mr. Chairman.
Representative Singh.
Thank you, Mr. Chairman. I would like to echo the Vice Chairwoman's concerns. And just, I'm trying to weigh out the pros and cons to this bill. I definitely see how having the public, having a public employer provide that financial service would be problematic. when it's being done on behalf of an employee to advocate for a particular union. However, it feels like this bill is targeted towards especially one specific union. And even though in many cases I vehemently disagree with the stances that this particular union may have, and I vehemently disagree with that they're influenced on by their national level of their association that educates them. I wouldn't in any way, shape, or form want to strip them of their voice. I think that would be a mistake. And so I see the problem that's trying to be addressed here. I'm just not sure if this is the way to do it. Thank you.
Thank you. Is there any further discussion? Representative Bratton.
Thank you, Mr. Chairman. I'll be quick. I actually am more comfortable with this now that we have stripped out that language with just singling out, the labor union. And also I'm going to look further into the Supreme Court precedent, USERSA versus Pocatello, Education Association, which held the states are not required to facilitate payroll reductions for political purposes. So I would refer people to that as well to look, which address the constitutionality of doing this. So thank you.
Thank you. Any further discussion? Representative Strock.
Thank you, Chairman. I sometimes really get bothered that we just throw bills away when we actually can get them going, and you can do a little more research before it comes to the House floor, and we can add amendments on the House floor. So sometimes we think we need this perfect bill as it leaves the committee. That's not what it's for. We have it to get out for the rest of the House to hear it and add amendments and have time. So I will be a yes on this, and hoping that some of us could get it out of here so we could look at it and work on it, because that's what we do in that. Once it gets to the floor, we add amendments there and we all vote on them there also.
Further discussion? Representative Lawley.
Well, I appreciate my friend and colleague and her suggestion. We are in a heated budget cycle right now where we are already facing delays in the schedule and bills are dying as we speak. And so just not the right environment to do what it is. I mean, if we wanted to pursue it as an interim topic or something where we can get it right, but something where I feel like we have some legal exposure and we haven't just quite gotten it right yet. And so that's why I'm a no, and it doesn't really change the dynamics. If we were in a general session, I might say, oh, okay, maybe we could do that, but I just don't see that happening. Reality's starting to set in.
Representative Erickson.
I would echo that same, Mr. Chairman. Thank you. I just think we're kind of doing ourselves a service by taking on these things, that there are all these questions that we have about this particular bill, and that we're taking it on right now and saying, oh, well, we can amend it when it gets to the floor. I just don't think we're even close to having the amount of time that we need to make this right.
Thank you. Representative Williams, did you have anything else to share with us?
Thank you, Chairman. Thank you, committee. I appreciate all the discussion we've had. And I do believe that it's been made clear in testimony that this takes away no one's right to be a member of any union. It just establishes that your public employer is not your accountant. I need to make that choice myself if I'm a public employee. And I appreciate the talk of amendment, and I believe if it's an issue of time, I think the schedule will kill the bill. will run up against the deadline in a budget session, and it will die that way. And so I'd encourage an aye vote to take it to the floor to where it at least has a chance to be discussed further. Thank you.
Thank you. And one final comment from me would be that I've been doing this for 6 years now, and I have the amount of times I have received comment from public employees in various professions who want to voice an opinion different than what the people who are here representing them are saying. But for that reason are unwilling to share their identities with me for fear that they will be retaliated against and even lose their job is my motivation for voting aye on this bill. Thank you. Further discussion? Question having been called, please call the roll.
This is a roll call vote for House Bill 178 as amended. Representative Braden? Aye. Representative Erickson?
No.
Representative Guggenmoss?
Aye.
Representative Kelly is excused. Representative Lawley?
No.
Representative Singh?
No.
Representative Strock?
Aye.
Representative Williams votes conflict. Chairman Andrew?
Aye.
Mr. Chairman, you have 4 ayes, 3 noes, 1 excused, and 1 conflict.
So, okay, thank you. House Bill 178 has passed the committee. Thank you.
Mr. Chairman, are we adjourned?
We are adjourned. Thank you.